Apologies, Your Honor. Yes, sir.
Your Honor, I'm sorry, we just put you on YouTube. I forgot I had taken you off.
We're
Here
okay.
you go.
And Ms. Levenstein, is this your signature on this document, ma'am?
Yes.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Rivera, is this your signature on this document also, sir?
Yes, it is, Your Honor.
And Ms. Levenstein, as attorney for Mr. Rivera, is this your signature on this document?
I signed the certification of Mr. Rivera's appellate rights, but I don't remember signing it after it had already been decided that he'd be revoked.
No, this is not that. This is a trial court certification of defendant's right of appeal. This is
Yeah, I signed that. Yes.
all right, then we're good. It's my understanding that in Mr. Rivera's case number 651285, this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes.
Okay. Mr. Rivera, on clause 651285, on the motion to revoke community supervision, how do you plead, sir?
Not guilty, Your Honor.
It'd be either true or not true.
Oh, true. I'm sorry. True, Your Honor. Excuse me.
Court accepts the plea of true with an explanation. How's that?
Yes.
Mr. Gross, would you please advise the court and the parties of the status of Mr. Rivera's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Rivera has been reporting as directed. We last saw him on May the 10th of 2022. He has not made any payments towards his fees and has a balance of $70. We have no proof of completion of any of his 40 hours of community service, and we have no proof of enrollment or completion of a victim impact panel, DWI intervention class, or the CATSNP program or VA equivalent. He was ordered to obtain a Smart Start mobile device within 5 days of his being placed on probation, February 3rd, 2022. And I show that he did not obtain his Smart Start mobile device until yesterday. So 3 months later, then he was ordered to obtain the device. This is his first violation report, first MTR. His prior arrest history includes 2 DWI 0.15 or higher, assault, family choking, strangulation, ×2.
I object. I don't understand what his past history may or may not prove whether or not he did or didn't do the things alleged on the motion.
It has nothing to do with what he's done or hasn't done recently. It has everything to do with what his criminal history is.
And then he has a case in County Court 7 for a violation of bond protective order. The defendant was originally granted permission to move to Florida when he was placed on probation, but it looks like he still is currently residing here in San Antonio. He's had 1 negative drug test, and his officer is recommending that he be sent to the intensive supervision facility, and then he go on a drug patch within 5 days of release.
And Ms. Levenstein, what are you requesting?
I would request that you continue him on probation. He was placed on probation for 18 months. We're only 3 months in. He obviously must be reporting, and I don't know anything about this negative drug test. There's nothing on the motion alleging it, and there's nothing on the court summary except for in the, one of the requests is for him to get a.
It's a negative drug test. There's nothing against him. It's negative.
Okay. All right. So, okay. Can I go through the conditions one by one, Your Honor?
Sure, any way you want to do it.
All right. So failure to complete 40 hours of community service, that's true. His VA benefits were stopped incorrectly, I'm told, for a while, but now he's got his income coming back. And so he can begin getting caught up on all the things that he owes. Also, he was told that he could pay that off in some way besides actually doing the community service. So we can talk about that later. He does have a Smart Start device, and yes, he got it recently.
Wait, let's stop there.
Okay.
And correct me if I'm wrong. My understanding is he was told to go on a Smart Start mobile device on February 3rd, 2022, when it was part of his conditions when he entered a plea to this case. Do you agree?
Well, the allegation says he failed to obtain a Smart Start mobile device. And technically, as of we sit right here, that is not true.
All right, Brenda, what I'm trying to establish is A, when he knew he was supposed to get a Smart Start mobile device, and B, when he actually got active on a Smart Start mobile device. Those are the two dates I'm looking for.
Okay, well, according to the CLO, and I wasn't present when he was put on probation, but she's alleging, and I have no reason to dispute that he was told to get it within 5 days, and obviously he did not. But he has had financial difficulties, and that's the cause of that.
Okay, so we all agree that he was supposed to get a Smart Start mobile device within 5 days, maybe 10 days of February 3rd, 2022. And that didn't happen, but he did get a Smart Start mobile device apparently yesterday. Does that make sense?
That's correct, Your Honor. I am looking at the record on the computer, and it shows that he received his device yesterday.
So he went approximately 3.5 months without a Smart Start mobile device. We all agree?
Yes, but he's also on 2 other probations, Your Honor.
Do they order him on a Smart Start mobile device or a Scram device or some sort of alcohol testing device?
I don't know. Mr. Rivera, are you being monitored for alcohol consumption on your other 2 probations?
Yes, I am. Monthly, at first it was weekly, and then it became monthly UAs for drug and alcohol.
And they have been taking your urine and testing it?
I have, yes, ma'am.
He's got no motions to revoke on the other 2 cases.
What are the other 2 cases he's currently on probation for?
The violation of protective order and an assault, felony assault.
Does he have any jail time on those 2 cases that might also be considered counting on this case?
I don't know. I know that these cases happened and were adjudicated in such a way that they weren't violations of probation because they occurred before he was placed on probation. But I don't have a chart here telling me exactly when each one happened. I can look that up if you want.
Yes, somebody that can look that up would be a wonderful thing. All right, I got it so far, Ben. Go ahead.
Okay. Number 16, failure to attend or register for a DWI intervention program. I was told that Mr. Rivera completed that on another case, perhaps one that he's on probation for, but that he was told by you that that would be sufficient and he wouldn't need to do it again for this case.
All right, let me back up a second. We're talking about condition 16 where it says that he was supposed to attend a DWI intervention program, correct?
Correct.
And he says that I told him he didn't have to go to that?
No, that he had already done it and that would suffice.
When did he do it? On another DWI probation, I guess?
Negative, Your Honor.
Go ahead.
Sir, I did it when after the DWI occurred. I was instructed to go ahead and start doing courses. Well, one of them was to do outpatient treatment, and I could do that through the VA. And I have that letter here, and it was in my file, and I also gave it to the new probation officer that I just recently received. But I started it, let me see here, August 5th, 2021, and I completed it December 6th, 2021. And it was 2 classes weekly.
And that was an outpatient drug alcohol program with the Veterans Administration. Does that sound right?
Yes, Your Honor.
All right. That's complete. And I'm the first one to tell you, all these different courses are very confusing. We would call that an outpatient drug course. What this is called is a DWI intervention program, which is completely different from that one. But that's neither apples nor oranges. Let's just tell me what you did in the military. What did you do in the military, sir, to have VA access at this time?
Military police and explosive canine handler.
And did you go to the war in Afghanistan or Iraq?
Yes, Your Honor, I did 2 times apiece.
How come you didn't get accepted into the Veterans Treatment Court on this case? Any way of knowing that one?
I was told that I was in the Veteran Treatment Court, and that's why I was transferred over to you from County Court 7 from Judge Rangel.
Okay, well, you're not in the Veterans Treatment Court. That's kind of why I was asking.
Judge, if I may.
Okay.
Yeah, sure.
I'm looking at his documents and stuff, and it looks like there is a vet court contract on an old case from 2017.
Mm-hmm.
Now, he does have that case in County Court 7, but I'm showing that the jurisdiction on that case is still in County Court 7. It is not a County Court 6 case.
So, Mr. Rivera, did you actually complete the program in the Veterans Treatment Court in 2017 on another case?
Yes, Your Honor, I did.
All right, that's why he's not eligible to do it again. You can't do it more than once. All right.
Gotcha. Okay, I was not aware. I was just, the last lawyer just told me that's why I was being transferred
That
here.
makes sense now. All right. Brenda, sorry for me interrupting you. I'm just going to have questions from time to time. Go ahead.
That's fine. No, that's what we're here for. All right. So now the catnip.
But let me jump in here. Catnip, if he went to outpatient drug with the Veterans Administration, I wouldn't make him go to catnip. So he that may be what he's talking about when he says he was going to get credit for one of these courses by going to VA. So I'm not worried about that.
And Judge, I've been reviewing his documents. We have proof, zero proof of any completion of any classes. The only thing that we have proof of completion of is victim impact panel in 2018. So the court would need to decide if you want to grant credit for that.
Okay. So that was number 17. Let's talk about 18, Brenda. I guess that's another
He's
program.
doing that this weekend.
Okay.
Actually, I was told I could go today, but because I contacted them.
All right. Well, let's cut to the chase on the elephant in the room. I'm most concerned about the fact that he did not become active on a Smart Start mobile device, so we weren't able to monitor him for 3 or 4 months. That's the big issue. So I'm trying to figure out why he didn't do that. And I think you mentioned something about, oh, gee, I can't afford it, but that was never brought to our attention.
There's a reason for that, Your Honor. I was with I was with a probation officer, I think it's Diana Cisneros. She sent me one email when I was supposed to have a meeting with her. I never got a contact. I emailed her and I got an automatic response from her stating that she was on maternity leave. It took me a while, but I finally got a hold of Miss Lauren Rivera, who I guess is a supervisor for a section of the probation department. And she got me in contact with Mr. Finesca and John Fonseca, excuse me. And I finally got in touch with him back in, up until recently. So I had no contact with a probation officer to keep people updated on anything, to let them know what the circumstances were, anything like that. So there was no communication for me to relay anything, or for any, or the fact that nobody told me, they were leaving and transferring my paperwork to someplace else, and I was never updated.
Okay, got it.
Okay, Mr. Rivera,
And I have those
you
emails as
signed
well.
your conditions when you went to orientation, and you were told at that time, and you were given a list of the Smart Start locations in which you had the specified amount of time to get the device. So whether you've had one officer or 14 officers, that doesn't matter, because you were told at orientation and given the information.
Roger, ma'am. And also I was my new probation officer, because I had went with a different location instead of Smart Start. And he told me that I couldn't do that because Judge Christian has Smart Start that he wants to go with, and that I wasn't allowed to make a selection from what you guys gave me. So either way, the information was wrong, and I still would have been in trouble because I went with somebody else. Is that what I'm getting? What would have happened?
Your conditions specifically state Smart Start. Even if you were given a list with other things on it, your conditions.
The reason I had asked, because you just said I was given a list to select from. You had just stated that. So that's what I was
Right.
asking.
Okay, Richard, hold on, just,
Let me interject. Were you on some other device other than a Smart Start mobile device?
No, sir, I wasn't. I was going to be, and I got in trouble for not doing it, or
All right.
for doing that.
All right. Ms. Levenstein, go ahead, please.
no, I think we're done. If I can just sum up.
Sure, go ahead.
He pled true. He's admitting that he didn't do everything exactly as he's supposed to, but it's early on in his probation. He finally got his funding back in. I don't think this is a person that needs to be sent to jail for 13, 14, 16, 17, and 18. He didn't commit a new offense. He hasn't tested positive for anything. He's on 2 other probations that at least one that he has had his urine tested. The probation office should have access to that information. He's got the Smart Start. He's going to do the victim impact panel. He's served our country valiantly. I just think that he should be continued on probation.
State recommendation?
Your Honor, the state recommends continuing, but keeping him on Smart Start Mobile for what would have been half the term, which is 8 months. We would also request weekly UAs and substantial compliance within 10 days.
And Susan, do you know what the original fine amount was on this case?
Yes, Your Honor, the original fine was $150.
Anything further, Ms. Levenstein?
No, defense rests.
Mr. Rivera, on cause 651-285, the court accepts your plea of true with an explanation on the motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail, $150 fine plus court cost credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on May 23rd, 2022, recalling all pretrial services, bond conditions, and prior warrants. The only reason you're not going to jail for a full year is your military service, and you did a few things on this probation. But the fact that you refused to get a Smart Start mobile device, having been in the military and knowing how to follow orders, is not something that we can easily forgive. Anything further from the state or the defense on Mr. Rivera?
Nothing from the state, Your Honor.
No.
Good luck, Mr. Rivera. Thank you, Ms. Levenstein.
Mr. Levenstein,
Yes,
can I speak with
in a
you?
breakout room and chat, you're welcome to do that.
yes, please.
Are we
Yes, of
ready
course.
on Ms. Garcia's case, Mr. Herbst?
Yes, we're ready to proceed, Your Honor.
Thank you. It's cause 620258, State of Texas versus Blanca Garcia. This is a motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, that purportedly has both Ms. Garcia's and Mr. Herbst's signatures on it. In fact, Ms. Garcia, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Mr. Herbst, as attorney for Ms. Garcia, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And Ms. Garcia, is this your signature on this document also, ma'am?
Yes.
And Mr. Herbst, as attorney for Ms. Garcia, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. Mr. Herbst, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
That's correct.
Ms. Garcia, in cause 620258 on the motion to revoke community supervision, how do you plead now?
True.
Be true or not true, and probably with an explanation you're welcome to add.
true,
Mr. Gross, would you please advise the court and the parties of the status of Ms. Garcia's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Garcia has performed very poorly on probation. We did last year, May 11th of 2020. She missed the last 4 months of her required reporting. She was arrested and charged with a new assault bodily injury, which did end up being dismissed. She only paid $134 towards her fees. She has a balance of $951. She did complete 30 hours of community service as well as her theft class. She had 1 positive drug test for marijuana, 6 negative drug tests. This is her first violation report, first motion to revoke. This case did expire on March 24th of 2020. And that was after she was, or I apologize. She was given an extension. Her original expiration was March 24th, 2020. She was extended to 9/23/2020. And she failed to comply with that extension. She also had a no contact order with Target. Her arrest history includes failure to ID, 2 burglary of a habitations, a theft 20 to 500 by check, theft 100 to 750, failed to ID and giving false info to a law enforcement officer, an assault bodily injury, as mentioned, that was dismissed. And her officer is recommending that if she pays in full, that her case be terminated. And if not, that she be revoked and placed on regular probation so that the monies can be paid and she can complete her classes.
State theft $100 to $750 in Texas Class B, is that correct?
Yes, Your Honor.
Defense, you agree?
Yes, it's a Class B.
So Mr. Herbst, what are you requesting?
I'm requesting that she be terminated on SAT. The biggest part of the violation is her failure to pay, but she's got an inability to pay, partly due to maybe, shall we say, learning disabilities, and partially due to the COVID economy.
State recommendation?
State recommends terminating probation unsatisfactory.
Ms. Garcia, on cause 620258, court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assess a $250 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, May 23rd, 2022 to serve your sentence, recalling all pretrial services, bond conditions, and warrants. Anything further from the state or the defense on Ms. Garcia?
Nothing from the state, Your Honor.
Nothing from the defense.
Good luck, Ms. Garcia. Thank you, Mr. Herbst.
Thank you. May we be excused?
You bet. Are we ready on Mr. Madiskal, excuse me?
Yes, Your Honor, we're here.
655-640, State of Texas versus Jonathan C. Madiskal. This is a first amended motion to enter adjudication of guilt and revoke community supervision. And the first document we have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. It is purportedly signed both by Mr. Madiskal and his attorney, Mr. Trevino. In fact, Mr. Madiskal, is this your signature on this document, sir?
Yes, it is, Your Honor.
Thank you. And Mr. Trevino, as attorney for Mr. Madiskal, is this your signature on this document also, sir?
It is.
Thank you. The next document I have on this case is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. In fact, Mr. Madiskal, is this your signature on this document also, sir?
It is, Your Honor.
Thank you. And Mr. Trevino, as attorney for Mr. Madiskal, is this also your signature on this document?
It is.
Thank you. Mr. Trevino, my understanding is that this is going to be an uncontested first amended motion to enter adjudication of guilt and revoke community supervision. Is that correct?
It is, Your Honor.
Mr. Madiskal, in clause 655-640 on the first amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
True with an explanation.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Mariscalco's probation?
Yes, Your Honor. He's been reporting okay. We last saw him on May 12th, 2022. He did miss reporting the month of April 2022. He has paid $1,039 towards his fees. He's current at this time, and he has a balance of $200. We have no record of any of his 48 hours community service having been completed. He has completed DWI education, victim impact panel, and the CAT-SNP programs. He's currently testing on Smart Start Mobile at 4 times per day. Excuse me. And he has had 14 skip tests and no high BRACs. This is his first violation report, first MTR, no criminal history. His officer is recommending that his probation be extended on an additional 3 months, that he be kept on the Smart Start Mobile for the full term of probation, and that the court add the intensive outpatient program through CATS.
So we've got 4 months left on his probation in a perfect setting. Is that correct?
Yes, Your Honor.
Over. Yeah, 5 months.
4.5.
Okay, defense, Mr. Trevino, what are you requesting, sir?
On the 48 hours of community service, my client intends to pay a donation to the Wounded Warriors, if that's acceptable to the court. So he can finish that condition out. And I believe that what the state was recommending was to just do weekly UAs for the remainder of the term. And we're good with either recommendation from the CLO or from the state. The state wanted to have the UAs added just to make sure that he's compliant.
And Judge, if I may, I apologize. I failed to go over his UA history. He's had 1 positive for marijuana, 4 negatives, a failure to submit, and 5 dilutes.
As to the diluted offenses, Judge, I provided medical records we have provided medical records to probation and to the state. My client has a problem with frequent urination, and I'm assuming that might be a reason that on the times that he was diluted is because he has that issue. He's been told to go see a urologist, and at the time he doesn't have insurance, so he hasn't done so yet, but we're pending that examination to figure out if that's what's going on here.
This is a lot of dilutes. Now, here's my confusion. If you're on a diuretic or you have to urinate all the time, that would help you not get a diluted test. That wouldn't give you a diluted test. You're getting rid of liquid. You're not getting more liquid in your body. And Ms. Gross, correct me if I'm wrong, doesn't a human being have to drink an incredible quantity of liquid like water to actually come out as a diluted urinalysis test?
Yes, sir. That is my understanding.
Is there any reason that Mr. Mariscal during this time frame had to drink a lot of water for some reason?
I have no idea, Judge. I don't have an answer.
Ask it, Mr. Mariscal. This is a lot of diluted tests. And let me just put my cards on the table for you. It's a standard knowledge within the industry for people that don't want to come up with a positive blood test for something like marijuana, that they know, because it's system knowledge, to go out and drink a lot of water before a test, and then that dilutes it, and then it can't be tested. So that's what I'm dealing with. I'm trying to understand from your perspective why we're getting all these diluted tests if you're not hiding marijuana hits from me. Hang on, Susan, go ahead.
In reviewing his documents that we have on file, I do find 1 set of medical documents that we have. And all that says is that he had a shoulder injury. There's nothing in there about urine.
It's right underneath that, or that if it's the same document you're looking at.
Well,
I've got a question for Mr. Mariscal with Mr. Trevino's permission. I'm just trying to determine why you would have drunk a lot of liquid on these dates when we got all these diluted tests.
I did not do it on purpose, Your Honor. And if you can see that when I did dilute, my probation officer he did give me a chance to go again, and I was able to pass. It just, I'm always active. I work a lot. I don't work in an office. I'm always working in kitchens outside, and I'm always drinking a lot of water. I like to stay active. I'm not trying to get away with anything. I did pass it on like the second time that he gave me a chance on. I was just having a hard time producing a clear sample for them.
Okay, I got it. State recommendation.
They recommends weekly UAs, increase the start mobile to 6 blows a day for 30 days, and substantial compliance within 10 days.
And anything further, Mr. Trevino?
Nothing further, Your Honor.
Mr. Maniscal, in cause 655-640, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated, first offense. I sentence you to 6 months in the Bexar County Jail, probated for 6 months, assessing a $500 fine plus court costs, which I think was the original fine, Susan. Does that sound right?
Yes, Your Honor.
And we're 48 hours community service, the original amount of community service?
Yes, Your Honor.
48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program. Weekly UA, show me 4 clean weekly UAs in a row, and I'll put you back on monthly UAs. If you do that, you need to let your attorney know you've done it. He lets me know. I confirm it with probation, and we put you back on monthly UAs. I'm going to crank your blows on the Smart Start Mobile up from 4 blows a day to 6 blows a day. If you show me a 30-day period of time blowing 6 blows a day, where you don't miss any, you don't skip any tests, and there are no positives for alcohol, I'll crank you back down to 4 blows. I won't know you've done this if you do it. Once again, you got to let your attorney know. He'll let me know. I'll confirm it with probation. You get credit for anything done, any monies paid, any programs completed. That's basically it. State, what did I miss?
Substantial compliance within 10 days, Your Honor.
Like that. And substantial compliance within 10 days, which I think he's already done. What courses does he need to complete still, Susan?
He's done them all, Your Honor. The only thing that he's lacking is the community service.
All right. He's welcome to either do community service or to donate $10 an hour to a designated court charity, which are primarily Special Operations Wounded Warrior Organization or Family Violence Prevention Organization. And there are a few more that their probation officer will have a list of. That's what I got. Anything further from the state or the defense on Mr. Maniscal?
Judge, to clarify, Smart Start will be half term, correct?
That's a good point. Yeah, Smart Start Mobile at 4 blows a day will be for half term, which is 3 months. So it's 90 days if you do well. And right now you're going to be on 6 blows though, because that's my sanction for you. Instead of putting you in jail for 6 months, I thought perhaps we would just make you lose sleep for a while. Would that be okay with you, Mr. Maniscal?
Yes, Your Honor.
All right. Okay with you, Fernando?
Absolutely, Judge.
All right. You guys take care.
All right, thank you.
Yes, I do have some instructions. Fernando, Pat's going to be sending you some documents right now. You need to fill those out immediately and return them to her. And Mr. Mariscal, you're going to also be receiving some documents. You need to fill those out and return them immediately. It is your application for probation and your data sheet. Okay. Once you do that, then it's going to go over to the probation department. They will call you. If you don't hear from the probation department intake by next Wednesday morning at 10 o'clock, you need to get in touch with your attorney or your probation officer, or you can call intake at 210-335-7446. Because you're starting all over. So you got to go through orientation once again. Okay.
Okay.
One other thing, Judge, I believe that because they amended the MTR, you entered a warrant. We need that recalled. We've already heard the MTR.
Pretrial bond conditions and warrant. So that I will go in today. It may not become effective till tomorrow because all my clerks are backed up. So be careful driving or whatever you're doing, because you're likely to still be hot on the computer until tomorrow.
Thank you, Judge.
Yes, Your Honor.
Okay. All right.
Call your attorney. He'll call me and we'll get you out as soon as we possibly can. But hopefully you won't have any interaction with with law enforcement and it won't be a problem.
Thank you, Your Honor.
All right, thanks, guys. You're out of here.
All
Good
right,
luck.
thank you.
Okay, are we ready on Mr. Perez? Mr. Foley?
We are, Judge.
Cause number 669950. State of Texas versus Travis Perez is a first amended motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have the signature of both Mr. Perez and his attorney, Mr. Foley. In fact, Mr. Perez, is this your signature on this document, sir?
Yes, Your Honor.
And Mr. Foley, as attorney for Mr. Perez, is also your signature on this document.
It is, Your Honor.
Next document I have on this case, and Mr. Perez, I apologize if you turn your microphone off unless we're talking to you. We won't get any background noise out of the jail. Thanks, sir.
Yes, sir.
Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Perez, is this your signature on this document also, sir?
Yes, Your Honor.
And Mr. Foley, as attorney for Mr. Perez, is this also your signature on this document?
It is, Your Honor.
Okay. Mr. Foley, it's my understanding that this is going to be an uncontested first amended motion to revoke community supervision. Is that correct?
That's correct, Your Honor.
Mr. Perez, in clause 669950 on the first amended motion to revoke community supervision, how do you plead, sir?
I plead true.
Thank you, sir. Ms. Gross, would you please advise the court and the parties of the status of Mr. Perez's probation?
Yes, Your Honor. Mr. Perez has performed very poorly on probation. He did last report February 4th, 2022. He missed January, March, and April of this year. He paid $281 towards his fees. He has a balance of $1,310, and he is delinquent $396.66. We have no proof of any of his 48 hours community service having been completed, and we have no proof of enrollment or completion of DWI education, victim impact panel, or the CAT-SNP program. He's had 3 positive drug tests, 2 of which were positive for marijuana, 1 positive for alcohol, and 0 negative tests. Those were all through urine. He's currently on Smart Start Mobile, testing it 4 times per day. As alleged on the motion, up until December the 5th, he had 35 skip tests. Since the motion was filed, he's had an additional 106 skip tests. He has had high BRACs, first one occurring on November 19th, 2021 at 0.035, and he failed to do a retest, and that was at 8:05 in the morning. On February the 8th, 2022, 0.022, no retest at 7:03 p.m. Then he had an additional one on February 17th, 2022 at 6:23. And that was at 0.021 with no retest. His last blow that we have on file was on March 2nd, 2022, and he has been in lockout since March 7th, 2022. He has no arrest history, and his officer is recommending that if he is continued, that he receive a jail sanction and be placed on a SCRAM device, and that he show substantial compliance within 15 days of his release from his jail sanction. Or should the court decide to want to keep him on probation, they are recommending that he be revoked, placed on regular probation, and add SATF and aftercare. Or I'm sorry, not revoked, that he be extended for a period of a year, add SATF and aftercare.
And Mr. Foley, what are you requesting? And your microphone's turned off, John.
I'm sorry, Judge. I forgot I had turned it back off. We would ask that that Mr. Pettis be continued on probation. He's still got like a year to go. So it's not like the court, is going to lose jurisdiction anytime soon, even if you don't extend it. But if you extend his probation, we would have no objection to that. We would ask that you give him a jail sanction. And he's got 17 days in, Judge. They're right now they're giving 2 for 1 at the jail. I had thought they were giving 3 for 1, but it's only 2 for 1. But also, I will say this, Judge, Mr. Pettis has been obviously a terrible screw up on this, and he understands that. He realizes that. He takes responsibility for it. He's not making any excuses to for any of this stuff. However, I think this is his first MTR. It's also his first arrest, and his second arrest, but this is his first case. And he has, I think, sort of gotten a taste now of what jail's like. And guess what? He doesn't like it. He also thinks, though, and he said, he told me he can do his time, but he honestly wants to quit, Judge. I think he's really motivated now to just stop drinking entirely. And he thinks that that probation with Scram will give him a better shot at doing that, that he'll be supervised. He doesn't think he can do this by himself. Judge, yeah. And that's what we're gonna ask for. Mr. Pettis is employed. He works at Docket Tree Care. He's an arborist, but he's aspiring to become a certified arborist, which takes a lot of classes, a lot of testing. And Docket Tree Care is supporting him in that. And I think this isn't a dishwashing job. This is a career, and I think it would be kind of a tragedy for someone to lose their career over something like this. He also is about to lose his apartment and his car. Again, Judge, he understands that is entirely his doing, but he's begging the court for mercy in that arena.
State recommendation.
State recommends revocation, Your Honor.
Mr. Perez and cause 669950. And Susan, what was the original fine amount on this case?
Judge, it was $700.
Court accepts your plea of true on the first amended motion to revoke community supervision. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assess a $700 fine plus court costs, credit for time served, time and money to run concurrent, recalling all pretrial services, bond conditions, and warrants. Anything further from the state or the defense on Mr. Perez?
Nothing from the state, Your Honor.
Good luck, Mr. Perez. Thank you, Mr. Fowler.
Your Honor, I'm sorry. I do have one thing.
Sure.
I do not think they have gone back to doing work release at the jail, but Brenda Levenstein told me that the other day she got a work release deal in a different court, and I would ask that the court order that in case they're still doing it.
My understanding is that what the jail used to call work release, we used all the time, as you're well aware. And that was that the individual would spend the night in jail, but work during the day. But they don't have that anymore because of COVID. So now what they call work release is a person has a GPS bracelet and is supposed to stay at home when he's not working. That's my understanding. And I'm obviously not going to do that. So
Judge, and I specifically asked Brenda about that. She said, no, it's real work release. It's jail.
I'm not going to do it in this case. Anyone that has stopped reporting, I don't have a warm, fuzzy feeling about coming back to jail every day. So sorry.
Okay. Thank you, Judge.
Good luck to you guys. Bye-bye.
Pat, can I get put back in a breakout room with?
Of course, that's what,
Thank you.
of course.
Okay, we've got Miss Morgan, we got Mr. Mason.
Judge, let me go turn on his computer or his stuff for him.
Let's take about 5 minutes actually so I can sign the paperwork.
The only
I'll be right back and then we can go into your,
You're gonna sign my motion without a hearing? Thank
Your
you.
Honor,
We'll
you
vote
don't
for
need to
today.
sign. It's only the defendant and the attorney. You just need to print it. That's it.
all right, then let me go print it.
Okay.
Good.
So is Eddie gonna be doing this or you, Arthur?
Eddie's coming back.
Okay, all right.
We had one MTR. I'd send it to Eddie. Do you want me to send it to you?
Yeah,
All
sure.
right.
I'll take a look at it.
5-minute recess.
Yeah, but you're muted now.
Okay.
Pat, we're still on YouTube.
I understand, but it's not gonna take the judge that long to print it.
Okay.
It'd take me longer to get it ready. You should be receiving the application pretty soon. I know Fernando has sent it. I'm not quite sure whether he hasn't, but I sent it to you, Susan, as well as the clerks, okay?
Yes, ma'am. Haven't gotten it as of yet.
Okay, well, just so that you know. Ash, for your information, Ashley,
Yes, ma'am.
just so that you know, the judge decided yesterday, County Court 6 is going full in person
Okay.
starting June 6th.
Okay, that's actually
Just so that you know.
better for me. I prefer in person.
Yeah, I think for everybody now, I think everybody's reaching that point. So just so that you know, I'm trying to let people know because now arraignment dockets will be in person. So we'll have to have the defendant there as well.
Okay. If the case is not filed, can we email you to waive arraignment?
I have no problems with you doing that, Ashley. What I've asked the judge is, what I have been doing is getting rid of and resetting all of the no files.
Okay.
There's no reason for y'all to do it. I want to continue doing that as well. It just helped the docket go a little smoother for everybody.
Mm.
And I'm sure, y'all don't want to come in just for no files.
Yeah.
Yeah. So I'm going to try to continue doing that.
Thank you.
Welcome.
Okay, we're on YouTube. This is cause number 660311, South State of Texas versus Michael Mason. My understanding is this is a motion to dismiss for lack of speedy trial. I have a document entitled Defendant's Consent to Hearing by Video Conference. On this case, purportedly signed by both Mr. Mason and his attorney, Ms. Morgan. In fact, Mr. Mason, is this your signature on this document, sir?
Oh, yes, sir, it is, sir.
And Ms. Morgan, as attorney for Mr. Mason, is this also your signature on this document?
Yes, Judge.
Ms. Morgan, would you outline for the court and the state the basis of your motion?
Yes, Judge. And I would also like for you to take judicial notice of the clerk's page with the different entries that have been made, and I will recitate those as well for the record.
Sure, I'll be happy to do that.
But this incident occurred allegedly on May 2nd, 2021, which is over a year ago. Mr. Mason was released on bond on May 4th, 2021, subject to this court's usual pretrial conditions, random UAs, no alcohol consumption, He was also ordered Scram Cam, Smart Start Mobile, which is quite expensive, as the court knows. In August, on August 23rd, 2021, I filed a writ of habeas corpus in this particular case, and it was heard. Some of those were granted. So he was reporting weekly, doing UAs. We have been set for trial. We appeared again on Monday, May 16th for trial. The state announced ready, the defense announced ready. We asserted our right to a speedy trial. And it was brought to the court's attention that there was no information filed. I did file this motion to dismiss for lack of a speedy trial on about May 10th, and that's why we're here.
Okay, before we get into this on both sides, let's everybody agree on the dates. What is the date of the offense when Mr. Mason was originally arrested?
May 2nd, 2021.
5/2/21, does that sound right?
Yes, Judge.
Okay, and no information has been filed yet, so there's no date on that. We all agree on that.
Judge, I did send the information for rush filing this morning.
Okay, so it's going to be filed today is what you're telling me?
It will be filed today, Your Honor.
Okay, thanks.
That's assuming he files up, Judge.
Ms. Morgan, how many days in jail was Mr. Mason forced to spend as a result of this case? Not necessarily from any violation reports. Weren't there some violation reports and I did bad things to Mr. Mason along the way?
Yes, and that's why we filed our writ, because there was no information filed. The blood alcohol concentration came back at about 0.053, which the state stipulated to at the writ of habeas corpus. There has been no toxicology returned. On the initial report, on the initial arrest, I think he did 2 days.
So, okay, so do we all agree he has credit for 2 days in jail at least?
Hold on, Mr. Mason has something.
Sure, Mr. Mason, go ahead.
Okay, thank you, Judge. Thank you, sir. In December, I did I think about 9 or 10 days in the COVID-19. What was that?
Yes, his bondsman filed an affidavit to release surety.
Your Honor,
Yeah.
I'm looking up
So
the
I went-
exact amount right now.
Right. And so I went straight, they sent me straight to the trustee tier. And so I had worked as a trustee in the main jail booking. So at that time in December, sir, it was about 19 days with the trustee, added the 3-for-1 good time. And also, sir, I spent from March the 10th and I just got out of the Bexar County Jail.
Your Honor, if I may?
Yeah.
He has a total of 59 days.
Okay, and that includes time from violation report probably?
Total amount is 59 days.
Bondsman coming off his bond perhaps
Yes.
and being arrested?
59 days is his total, Your Honor. I just checked.
Okay, and actually what level DWI is this?
It's a driving while intoxicated. The complaint says DWI open container.
That's how we
Class
filed
B.
it, Your Honor.
So class B right now.
But the blood or breath is 0.053, do we all agree?
Yes, Judge. We are waiting on toxicology report for a reason as well.
Let's
And
talk
Judge,
about that for a minute. If the arrest date is May 2nd, 2021, so that's approximately a year ago, you would have asked for a toxicology report probably right originally at that time, would you not?
Your Honor, typically they are provided to us the way BAC reports are given to us. They kind of just send them once they're available. I did check and we haven't received that. So I did request an update from our paralegal today to see why that hasn't been given to us. But because of the facts of the arrest, that is really the reason, what happened during the arrest and what was found is why we are so adamant about waiting on these toxicology reports.
Judge, they've had a year. That toxicology report should be back.
Oh, let's back up a second. So from the state perspective, everybody knowing there's at least one other side of the story and maybe more, what was aggravated about this arrest that would cause you to change any kind of standard operating procedure on getting your toxicology report, either faster or slower?
We're not sure exactly why DPS has not sent us the toxicology report, but the reason that we are waiting for it is because the defendant was found at the time of arrest in possession of what appears to be a fair amount of marijuana. And so although the BAC did come back low, we want to see if that possession of marijuana was consumed. And
they've had a year to provide those results and have not replied or reported those yet, and we are ready for trial.
Your Honor,
everybody stop talking, please. I'll be happy to let everybody talk as long as they want in just a minute. Was Mr. Mason charged with possession of marijuana in addition to DWI?
No.
Why not state?
I'm not sure why that file was not charged, Your Honor, but it was a fair amount of marijuana. It was about 28 grams. And so,
okay.
That's not
Judge,
correct.
that's okay,
That's
Mason.
not correct.
Talking, please. All right. Let me ask my questions, then you guys can ask your question. All right. So it just seems strange to me that somebody could have 28 grams of marijuana and not get charged for it.
No.
Your Honor,
Explain that. Is that what you're telling me?
I don't know the reason why it was not filed, but I am going to look into that. And if we filed it, we'll file that as well, and we'll proceed on that charge as well. But Your Honor, before we even get to the meat of the argument here, this motion for speedy trial is premature because we have not even filed an information until today. It's actually still awaiting filing. And so this motion for speedy trial, this motion for dismissal for lack of speedy trial is premature. It's not even a motion for speedy trial. They're asking for a dismissal, not a speedy trial. But even then, Your Honor, even if that is what they are seeking, there is no right to speedy trial before the accused has been formally accused. That it's in the amendment itself. It's in the Sixth Amendment language. And so this motion is premature, and we don't even have to go into the Barker analysis because there is no right to speedy trial until filing.
Okay, everybody hold on to your seat. Ms. Morgan, go.
Judge, we filed the writ back in August bringing you jurisdiction. That writ was partially granted. Once again, after August, the state had an additional 10 months to file the case. It's still not filed. I would like to call Mr. Mason to talk about the undue burden he's been placed upon being on bond and such.
Judge.
I'm sorry, go ahead, Eddie.
Judge, we would object to that as irrelevant, as that would only go to prejudice, which is one of the Barker analysis. We shouldn't even be getting into the Barker analysis at this point because there has been no prejudice. There's been no undue prejudice at this point that triggers that analysis for a speedy trial. Because as I mentioned, he has not been formally accused yet, Your Honor.
The state on the record said that they filed the information this morning, so we can recall this for tomorrow, Judge, if that's more appropriate for the state. But I believe you have jurisdiction.
Do it now, and here's how we're going to do it. Everybody can call any witnesses they want. They can put on whatever evidence they want. They can give me case law and do whatever. Because ultimately, I'm probably not going to rule today. I'm going to defer to my briefing attorney, Brooke, and have her research this for us on both sides to make sure we come up with an accurate evaluation of what the law applies and what law doesn't apply. So that being said, your motion is respectfully denied, Eddie, but we're going to go ahead and hear the whole thing today. And you may be exactly right, and maybe none of this matters or counts, but that's going to be up to me wasting your time. So we're going to do it this way. So at this time, Ms. Morgan, if you'd like to call Mr. Mason to the stand, I'll be happy to do that. Mr. Mason, raise your right hand, sir. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you, sir. Ms. Morgan, your witness.
And Judge, we're calling Mr. Mason for purposes of this hearing only.
Fair enough.
Mr. Mason, you were placed under arrest on about May 2nd, 2021, correct?
That is correct, ma'am.
What kind of bond conditions have you been under?
I had to take the weekly UAs. I had to have the Smart Start device installed. After COVID-19, this is my business card. I, I was licensed, bonded, and insured with the city of San Antonio, with the Grounds and Transportation Department, the San Antonio Police Department, being in the limousine business. I mean, out of all respect, 28 grams of anything was not found in my vehicle.
We're not going to talk about the evidence of this
Okay.
case, what the state alleged,
Okay.
because that's not in evidence. We're talking
Okay.
about bond conditions you were on.
Okay, yes. I volunteered and attended at least 140 sessions at the Club 12 AA group on San Pedro. I actually lost my apartment during these almost 2 months that I was incarcerated. I lost my business, the limousine business. It's been after COVID-19, the limousine business is not an essential business, so it's been a very major strain on myself. I've just I signed up at the reentry program. I went to a meeting yesterday to try to get assistance. To get assistance for an apartment, for assistance. I'm reapplying for jobs. So I've been under extreme pressure and financial strain during this course.
So you've lost your business, you said?
Yes, ma'am. I was licensed, bonded, and insured with the city of San Antonio, which we being licensed, we have to take a new analysis, every year. We have to, obviously, we can't obviously be drinking and driving, driving clients in San Antonio. I originally got evacuated here from New Orleans, Louisiana, back in 2005. So, I mean, I just completely lost everything, my apartment, my vehicle, to the Windcrest.
That was due to being charged, being under arrest and on bond for DWI.
Yes, ma'am.
What kind of, you talked about pressure, what kind of anxiety and pressure have you felt?
I'm just so happy to have this men's group. My ex-wife is an OBGYN, medical doctor for the University Health System. I have my circle of friends is just I just have a few friends here. Here's my support system here. I'm with the reentry program and a men's fellowship. We met just at the pretrial center at 6 o'clock yesterday. I have my apartment with Miss Ashley to try to get assistance. So emotional support. They're going to let me see a counselor because I've already lost everything. It's reflecting back to when I lost everything in Hurricane Katrina. I certainly apologize, for any inconvenience. It's just been a very financial strain on myself, and I wasn't exactly homeless when I had my home in New Orleans because we went to Kelly USA military base here. But for the first time in my life at 55, losing my business, losing my car, losing my apartment. I'm in a hotel for 1 week, and then I'm on a burden of the reentry to assist me. I can try to do some temp services tip work until I'm in the program to apply. My background is retail management. So I'm on the right track. I have a support team. I have a counselor because of the emotional support. I was crying a lot. I'm just,
How much do UAs cost?
They cost $20
Okay, and how often do you give a UA?
every week,
And how do you pay for that?
cash.
Well, where do you get the money from?
Since I've been working with a HireQuest, which is a daily, I get paid daily, which I have my my card here from HireQuest. That's from the, so I'm only doing this because I've been under so much extreme pressure to deal with this with the court and everything, and I don't want to apply for a full-time retail management position yet until this situation is totally resolved so I can finally move forward with my life.
Have you been denied jobs because of the pending DWI?
Yes, I have.
And how much does
Yeah.
Smart Start Mobile
And
cost?
I had applied, I had took the course for my CDL license. And so all of that is on hold. Here's the VIA is hiring for bus drivers. So I'm just scared to death because I certainly cannot afford, to have this type of situation on my record. I've been in the limousine business since 2008. And so I have to work very hard, get another vehicle, pay insurance. I'm going to continue. It's not a 13-week program. You can verify that through the pretrial counselor. So I have an ongoing support system of men that have had worse situations than I have. And they're there to support me, to talk to. I have a new church I'm attending, and I'm just asking for the mercy of the court, to please be so kind, to consider to work with me in a very special way under the circumstances of me losing, the limousine business, losing my car, losing my apartment, losing my storages. I don't have anything.
Pass the witness.
Mr. Villarreal, cross-examination.
I don't have anything.
Mr. Mason, you want to take a few minutes and just take your time, sir.
I'm sorry.
Take as much time as you need, sir.
I'm homeless. I've worked hard. I came here from New Orleans.
Ms. Morgan, is Mr. Mason in your office currently?
Yes, Judge.
Let's see if he wants to go to the restroom and paper towels, with the
Okay.
wash his eyes or something. He's welcome to do that.
Thank you. Your Honor, I'll